Good afternoon and welcome to the Senate Judiciary Committee. We're going to start the day by opening the public hearing on House Bill 49 and recognize the prime sponsor, Representative Edwards.
Thank you, Madam Chair. It's good to see all of you again, former House partner in crime. No, not in crime. I'm here to introduce House Bill 49 to the Senate. I am the prime sponsor, but this was also put together with Representative Lynn, Representative Leishman, and more importantly by the entire community. You all did great work on SB1. SB1 was sort of a complete package by itself. And when it came over to the House, what happened was if you've ever watched Star Trek, you know, the Enterprise can actually detach the saucer while the rest of it flies away. And so the House detached the urgent parts of SB1 while the body of SB1 sort of flew around the House many, many times, and the Klingons were all over it. But we held the day. HB 49 is introduced to you, passed the House on a strong 276 to 104 vote. If you want to look at the red and blue scores, one was 132 to 60, the other was 144 to 44. So in other words, I think it drew enormous nonpartisan, I'm going to say nonpartisan support. And the reason for that is because the community came out in force, and many of them are sitting behind me now, and they're really the force behind these 2 years of getting SB1 right, and then making sure that we didn't quit in the House to get the rest of the Starship Enterprise back to you all. So here it is. When you look at it, it's going to read very familiar to you. But if you got an LBA to like do a line by line comparison, looking for some distinctions, you would find a few tweaks here and there along the line. I don't think any of them have done anything but slightly improve the legislation. We kept the statement of findings. There have been op-eds written that say that HB 49 does not meet the statement of findings, and I assure you that that's just false. The statement of findings tries to keep kids in the state, tries to give them the right therapeutic care, and that's what this legislation does. We finally agreed on the biggest problem, which was the construction. Operational 12 with the physical capacity of going up to 18 should there be an exigent need to do so, with some flexible space so that if they have, needs to separate by gender or by gang affiliation or by any other reason, they have some flexibility to do that. As was introduced in SB1, it maintains the whole concept of community consultation, to do the responsible things, to work with the community, generate a report. I think that's the commission that got initiated in SB1 that survived the initial siege on SB1 in the House. There's a clear statement of government control over this. There was concern about this being a for-profit center. And so we've written the language consistent with the requests of the community to ensure that people know that this is a state-managed and owned and operated facility that is able to contract out, much like we do with Hampstead Hospital. So that's there. You'll see the phrase alternative flexible use. That has caused some curiosity. What does that mean? Well, there are some holdouts who think that we don't need to build this facility. And that came out on the floor last week. I don't know when that was. It feels like just yesterday. But anyways, that came out on the floor that there are people that think we don't need to even build this facility. So we disagree with that position. The House does, and the term alternative flexible use is meant to say build this thing in a smart way so that at some point, if the census gets so low that we don't need a secure facility for juveniles, you can convert that property to something else. So that's the ever hopeful clause. On page 2, lines 21 through 23, those words got rewritten a little bit and extended from what you saw in SB1. It's still the same concept, though. We always imagine that we should be co-locating this facility so that we can leverage shared services and some virtual services. And the extra wording is to make sure, what we would all assume is, but why not just spell it out? We would assume that it would be done with the best interests of the child in mind. And so that language was refined and extended from what you've seen. On programming and operations, I just want to point out to the community that one of the key things we're doing, and I think this is going to be kind of a cornerstone of why this is going to be successful, is that we have this uniform assessment in place so that some juveniles who get involved in the behavioral and mental health community might end up having an assessment developed of what their needs are and what the levels required are. But if they haven't by the time they've gotten to the Youth Development Center, one would be done, and that this assessment then would be used to tie together the discharge process to make sure that the ongoing care and support that juvenile needs is available, and hopefully will change enough lives that they'll want to take avail of the opportunity that the state is offering them. Page 3, lines 24 to 26. I think this is a great one, and this may have actually survived the earlier process, but even if it's a restatement, it says that DHHS shall begin to implement the programming changes without regard to whether the children are at the current center or in the new facility as soon as reasonably practical. So this is us telling them, go ahead and start making the changes to the trauma-informed therapeutic-based care as quickly as you can. It's going to be a challenge for them with the workforce issues that we have, but I think the fact that we're committing, I hope that Senate can commit to this. That's a great signal to the people who are there and the people who may want to work there that the state is, in fact, we have their back. Quarterly reports are required. It makes it clear, I don't think this was an SB1, that it makes it clear that when the site selection process has kind of run its course and has matured, it's the department that has the authority to make the decision. That was included at the governor's request. I think SB1 had said that the governor and the fiscal committee could agree to delay the opening by 2 years. We reduced it to 1, and that, we hope that it's not needed, but the way construction goes, it might be. It asks that we expedite the hire of an architect. I suspect the director has probably already hired the architect or darn near close to it. It talks about relinquishment. One of the things that you'll hear that came up new in the House is this concern that if you go back to the original deed that we have from 1855, it'll say in there that property can only be used to help take care of a mission of supporting children, wayward youth or something in the deed. And so that's been looked at before, and I've gotten Mr. Arlenhouse to go ahead and get his real property attorney looking into that. In my conversations with Representative Lynn, who used to know something about the law, maybe still does a little bit, he he said, well, if something like that is in the deed, then the state can file a blah-bitty-blah. And because I'm not a lawyer, that's all I heard, was that there's some blah-bitty-blah that we could file to maybe fix the deed. But with him here, he could use real words. On the appropriation, this is different from SB1. It came over with a $15 million appropriation. We went ahead and made it to 21.6, which was the most current estimate that we had. We also asked in here that all the funding be made out of federal funds. Now, Senator Rosenwald had asked me when the floor amendment was still to be heard, if I could file an amendment to my floor amendment that would limit the department by telling them that they shall not transfer any of the money or use it for any other purpose than the Sununu Center. And I told her then I didn't have a problem with the idea, but I couldn't. At that point, it was just too late to change my floor amendment. It was just too late. And so it's something that the Senate may want to consider. Senator Rosenwald said she'd be back to talk about it. I would ask you to consider not doing it in HB 49, though. Let's go ahead and get HB 49 through the goalposts. And this is a fix that's not going to be an issue for a while. We can add that to HB 2. Because we still have an HB2 process before us. And then when you look at the fiscal note, that's out of date because we've already appropriated the $1.5 million for the current operations for the balance of the year. So that fiscal note I don't think is particularly relevant. You got a lot of great people here, put in a lot of great work. A couple of them actually bought me beer after we got this passed, so that was pretty great. So I'm a big fan of this community, and with that, I'll take any questions if there are any.
Thank you very much, Representative. Are there any questions for Representative Edwards? Seeing none, thank you very much.
All right, thank you.
Okay, the chair will call. I see Representative Lynn. Is there anything that you'd like to add at this point?
The reference he made to the Attorney General, I think it's called a side bring action that the Attorney General can bring if he thinks that the property now would have a better use for it. They bring up the summary.
Okay, thank you. The chair will call Joe Ribson.
Good afternoon, Chair Carson and members of the committee. Joe Ripson, Director DCYF. Thank you so much for hearing from me. The department strongly supports this bill move forward as is. As you heard from Representative Edwards already, this largely mirrors or duplicates what came through this body already unanimously in SB1 with a couple changes that the representative brought up. I'm happy to go through any questions that folks have, but I don't want to, delay the committee's time by kind of belaboring the points that were already made. I would just say that this bill, I think, very strongly sets us forward on a path to replacing a large, difficult correctional style facility with a smaller trauma-informed therapeutic approach to working with kids and families. And critically, it integrates that work deeply into our broader system of care so that, as you heard Representative Edwards say, the kids get the same assessment process. The work starts with our system of care to transition them out to the community immediately upon entry and makes sure that when kids do go to the community, hopefully they're successful there and stay there. And with that, I'm happy to take any questions.
Thank you, Mr. Ribson. Senator Abbott has a question.
Thank you, Madam Chair, and thank you for taking my question.
Of course.
Is there any opinion on the potential of having a police officer or a state trooper that's on duty, and in my vision would be something parallel to a truant officer that you see at some schools? I'm not sure if you can speak on that and perhaps the pros and cons of such.
Yeah, I mean, I think there's a lot of ways to think about the security issues for the new facility, right? Whether you want to have a law enforcement presence or whether you want to structure that with thinking about staff roles and responsibilities. And I know this was a conversation that we had when SB1 was moving forward as well. And I think there was lots of ideas around the best way to do that. And I believe there's a commission that's being started out of what SB1 became to kind of vet through those ideas and figure out what the right way is to structure that. So I do think that's one viable possibility of working forward towards that, but I think there's probably a couple different approaches to think about making sure that the facility itself is secure and not likely to ever have to, rely on local law enforcement response.
Yes, follow up.
Thank you. And my concern, it's really the local law enforcement in the surrounding communities when they're 30 miles away from the nearest troop. So but I also think that some youth who has had interaction with law enforcement, and perhaps not all of them been positive, no need to, we're just speaking hypotheticals. Perhaps having a truant officer on site, not and wearing a traditional uniform, someone who's wearing khaki pants and a polo shirt, could have a benefit to the youth. I'm just wondering, is there any opinion on that?
Yeah, I mean, I think, again, like I said, I think I think that's a way to address it. I think there's multiple ways to address this concern. But I think that is a way. You'd want to be really careful that those folks who you're bringing in as law enforcement really understood youth, de-escalation, and really were much more of a supportive presence as opposed to kind of a security presence, at least in the way that they feel. Obviously, they'd have to be capable of responding in that way, but you wouldn't want that to kind of have a intimidating feel in a therapeutic setting. You really want to make sure that it's integrated in a way that it feels supportive to the youth and a necessary kind of safety response when needed. But again, like I said, I think there's a couple ways to achieve that goal, but I think it's good to put all those ideas on the table and come to some consensus.
Thank you.
Yep.
Are there any further questions? Mr. Ribson, I just want to make sure that everyone understands that in Senate Bill 1, there was a commission put together to look at security issues and to just be able to look at all options about what's going to work best for not only the new center, but for the surrounding communities as well.
Yeah, absolutely. We look forward to participating in that with, I'm sure, many folks here.
And just to make absolutely sure, I believe Senate Bill 1 has already been signed by the governor. So it's just a question of getting that commission together and getting them working.
Yep, that's correct. And I know that the department has already received outreach from the Senate President's office to identify a designee for it. So I think Senate President's actively working on getting that commission going.
Okay, thank you very much. Okay, next we have, let's see, why don't we go to Holly Stevens?
Good afternoon.
Good afternoon.
Chair Carson, members of the committee. My name is Holly Stevens. I'm the Director of Public Policy for NAMI, New Hampshire. NAMI is a grassroots nonprofit organization whose mission is to improve the lives of all people impacted by mental illness and suicide through support, education, and advocacy. And on behalf of NAMI, New Hampshire, I'm here today to speak in support of House Bill 49. I can't even speak today. House Bill 49 as amended by the House relative to postponing the closure of the Sununu Youth Services Center. As you likely know, under current New Hampshire law, the Sununu Center is funded through June 2023 with no appropriation for a new center. Senate Bill 1 as amended by the House, which passed into law earlier, contained an appropriation for the state to procure an architect, but not for a replacement facility. Without additional legislative action, there will be further delay in the building of a new youth detention center, and it would be irresponsible for our state to allow this delay to occur. NAMI New Hampshire applauds the efforts of the Senate, first through Senate Bill 1 as amended by the Senate, and now via the consideration of House Bill 49 to get legislation passed to replace the current facility and outline the environment, services, and treatment to be provided in the new facility. Many children that enter the juvenile justice system are there inappropriately as a result of unmet mental health needs. and a majority of the children in the juvenile justice system have a diagnosable mental health disorder. Therefore, NAMI New Hampshire strongly supports a new facility as outlined in House Bill 49 as amended by the House that utilizes trauma-informed care and provides services to meet the mental health needs of all children served in the center. We further support the plans contained in the bill to have staff trained to work with youth with behavioral health challenges and trauma histories, to use evidence-based practices in treatment, to provide frequent visitation opportunities for the families, and to implement educational program and staffing tailored to the individual educational needs of the youth, including special education needs. And lastly, we also support the plan to implement programming in the current facility as soon as it's practical to do so. Although the bill as amended by the House, you heard, passed on a voice vote, and the amendment to House Bill 49 that Representative Edwards brought forward did pass by a considerable margin, the prior votes in the House floor discussion on this and other amendments to the bill suggest that many members of the House do not support various provisions of House Bill 49. Therefore, if given an opportunity to reevaluate the bill during a committee or conference, the House could revert to a past position on the bill. And as such, NAMI New Hampshire urges the members of the Senate Judiciary Committee to strongly consider that as a possibility and support House Bill 49 as it came to you from the House, rather than considering making amendments at this time. And if you are considering any amendments, as it was suggested earlier, maybe looking at another vehicle to make those amendments so that this bill can actually go forward as it is, and we can get on with getting this new center built. And with that, I will take any questions.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Okay. Seeing none, thank you very much.
Thank you.
The chair will call Lissa Massis. Did I get that? Mascio, okay.
Good afternoon, Chairwoman Carson and esteemed members of the Senate Judiciary Committee. My name is Lissa Mascio. I am the new Associate Child Advocate at the Office of Child Advocate. Cassandra Sanchez, the Child Advocate, sends her regards and thanks today for the important work you're doing here. She's attending to other OCA work today, but does lend her support and the support of the entire office, along with many of the New Hampshire advocacy agencies you see here before you. We support House Bill 49 as amended by the House, which closely mirrors the fine work you all did on SB 1, as been stated previously. The Office of Child Advocate is here to prioritize the children, those currently at the facility and the few that we expect to serve in the future at a replacement facility. These children deserve a treatment facility, not a detention center. The small home-like environment that can provide appropriate trauma-informed therapy and treatment, individualized therapeutic care to address their complex trauma histories and unique needs. So who are these children being served? A recent point-in-time study done by the Office of Child Advocate highlighted that 100% of the children at the facility during that time period had a history of referrals to DCYF for suspected abuse or neglect. There was an average of 25 referrals per child, and out of those children, 60% of them had had prior out-of-home placements before being placed at the facility. So what does that tell us? All of the children have suffered complex trauma in their lives, much of which drove the initial behaviors that ended up leading to juvenile justice involvement. And it's critical to understand that these children are in need of support and treatment. And if we want to see positive outcomes for these children, we need to invest in them and to do so now. Most of the people gathered here today advocating for the passage of this bill see this issue from different perspectives within the same system. And at times we may be at odds, but we continue to stand in solidarity regarding HB 49 and what's best for that small population of children in our state that require this high-level placement for the safety of the community and the safety of themselves. The Office of Child Advocate also stands in firm agreement that SB 94, in conjunction with the Children's System of Care, were successful steps that the state has already taken to divert children from the juvenile justice system. We need to continue to keep these children connected to their communities and their families whenever possible. HB 49, as passed by the House, would allow us to continue on that path and keep these high needs children in the state of New Hampshire for appropriate care and treatment. When our children are sent out of state, we know that it severs connections that are necessary to their positive growth and development. The Office of Child Advocate has a unique vantage point of not only seeing and interacting youth here in the state of New Hampshire, but regularly engaging with our state's children that are placed in facilities outside of the state and across the country. These are children who have family and friends that love them and love them back here in the state of New Hampshire. We cannot continue to send our children away from their greatest supports because those supports can change their lives and lead to much better outcomes lasting into adulthood. So in sum, we stand in agreement with the division and the other child-focused stakeholders that individualized trauma-informed care administered within a smaller facility will not only support these youth more effectively, but it will reduce recidivism rates and future costs to New Hampshire's communities at large. By ensuring that a safe and treatment-focused facility that is properly and adequately staffed is created will only continue to meaningfully reduce the census and to build up New Hampshire's children's system of care. We urge this committee and the Senate as a whole to prioritize the children of New Hampshire by voting in support of House Bill 49 as amended without delay. And we do thank you for your tireless efforts on behalf of the children of New Hampshire.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you.
Thank you, Senator.
And next, we're going to call Karen Rosenberg.
Good afternoon. I'm Karen Rosenberg. I'm the Policy Director at the Disability Rights Center of New Hampshire, and I'm here to testify on behalf of the Disability Rights Center as well as the following members of the Juvenile Reform Policy Group: New Hampshire Legal Assistance, Waypoint, New Futures, and the Children's Law Center of New Hampshire. And we are testifying in support of HB 49 as amended by the House. We believe that children should not be unnecessarily ordered to secure placements, and whenever possible, children who become involved in the juvenile justice system should receive their supports and services and evidence-based treatment in their home communities. The sad reality, though, is that there are, and will likely always be, a very small number of children who courts detain or place in secure facilities. Currently, the only in-state secure option available in New Hampshire is the Sununu Youth Services Center, SYSC, a facility we all acknowledge is inappropriate for children. And without legislative action, this grim reality will continue indefinitely. New Hampshire needs an in-state, therapeutic, evidence-based, secure facility with an appropriate budget and staffing ratios for the small number of children who are court-ordered to secure detention or placement. This facility must not only provide medically necessary treatment and education services, but also immediately connect children ordered there to New Hampshire's system of care and support their transition back to their homes and community base where they would receive services. HB 49 as amended by the House, if passed, will allow this to happen. The alternatives to moving forward with HB 49 are not acceptable. They would include keeping SYSC open indefinitely, which we know is not an appropriate therapeutic setting for children who are so vulnerable, or sending children out of state to locked facilities in other states far from their homes, such as Arkansas, Mississippi, or Tennessee. Either of those options would be very harmful to New Hampshire's children. HB 49, as amended by the House, provides the authority and funding DHHS requires to move forward with the development of a safe, therapeutic, secure facility for the small number of children ordered to secure placement. It's nearly identical to SB 1A as the Senate passed it unanimously. And it's supported by a wide range of stakeholders who are actively working to advocate for the needs of children in New Hampshire. In addition to the organizations I'm representing today, that includes the Office of the Child Advocate, NAMI New Hampshire, CASA of New Hampshire, New Hampshire Coalition Against Domestic and Sexual Violence, the Juvenile Justice Reform Commission, the New Hampshire Foster and Adoptive Parents Association, the New Hampshire Juvenile Courts Network. Each of these organizations and more signed on to a letter expressing their support of HB 49 as it has now been amended. And I have copies of that letter, which I'll distribute to you if you haven't seen it already. But for all of these reasons, I request that you recommend HB 49 as amended by the House, that it ought to pass, that it not be further amended to avoid a committee of conference that could only serve to derail what really needs to happen now, and that's forward progress, so we can have a treatment-based facility for these small number of children and move on and work on other matters. I'm happy to take any questions.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you.
Thank you.
Are there any other members of the public that would like to speak to House Bill 49? Okay, seeing none, we're going to close the public hearing. Can I get a motion? Okay, we have a motion to move into executive session, seconded. Okay, in front of us, we have House Bill 49. Is there a motion on this bill?
I move on to pass.
Okay, we have an ought to pass by Senator Whitley, seconded by Senator Chandley. Is there any discussion?
One comment to make. So I understand the need to pass, I understand the overall need to pass this, but my concerns about this is the same. I don't need to repeat them all as with Senate Bill 1. I know there's been some more information that's come out. It's in all likelihood this is going to go where Hampstead Hospital is. I have not heard anything suggesting otherwise. I still have concerns about I have concerns about the police response time being 30 minutes away from a troop. I don't want to rely on a commission to address that. I don't need a commission to tell me, oh, we'll discuss the security issues. 30 minutes is 30 minutes. That's not the police's fault. I can picture people trying to blame the police for taking too long to get there when we know how far away it is already, that we're relying on local law enforcement. I know there's been some provisions in here to help alleviate that, but I would just like to have some more certainty in what we're doing, and so I'm going to struggle to support it without that. But I think the concept of we got to do something, I get that. Moving the facility, putting a youth detention center on the same grounds as the Hampstead Hospital. I know there was an agenda to separate the two, and there's some thought of putting them on the same facility may not necessarily be the best thing to do, but I understand it's what it is.
Okay, are there any other comments? Okay, seeing none, we have an ought to pass motion. Okay, all in favor say aye. Aye. Any opposed?
No,
Okay. And I will take this out, Matthew. Okay. The committee will be in recess for 10 minutes. Okay. Thank you, Dr. Yeah, you've got some time. Yeah. You're here for the next one? Okay, all right. Okay.
positive note, folders are working out much better than.
Yes, I know. It usually does. That's why I do that. Hey, I can only lead you so far. You gotta, it's just easier, and I have the folder like that. Everything is all together. Rather than, pardon?
It's getting the best.
Yeah, it's a lot of flipping around stuff, and it's just a pain.
Then I would get written testimony and I put in there and file.
Well, Peter is supposed to do all that stuff for you. Oh.
Thank you, Madam Chair and members of the committee. Representative Hole, serving the towns of Dunbarton, Hooksett, Allenstown, and Epsom, also known as Merrimack 27. Here to introduce and ask for your passage on House Bill 497, right, relative to the confidentiality of records. So for some background, the current process allows the department to collect some information and then choose to, because the commissioner or his or her designee can determine that this might be harmful to the child, can then fail to disclose this information to any parents. There is a list of people that the records can be disclosed to. It's a short list. It's parents, it's their legal counsel, it's the county, the government, whatever. There's a small group of individuals who have access to these records. They are confidential, and we're trying to protect the children. But the person potentially accused of something doesn't have access to what they've been accused of or what the evidence is that would be underlying of that accusation. And this provides the appropriate safeguards to have an independent branch of government take a look to see whether there's something necessary to share with the parent. And this is in keeping with several portions of our Constitution, and I will reference Article 8, Article 14, and Article 15. While Article 8 is broad, we consider this the right to know section, right? This is not necessarily broadly about the right to know, but it is about a citizen's right to know information. And midway through to that end, right, the public's right, or in this case, the individual's right of access to government proceedings and records shall not be unreasonably restricted. So if a parent has some accusation by the department in reference of DCYF, they should have access to all of the underlying information. Now, there might be a court case going on because it could be potentially a criminal investigation, in which case I'm sure the judge would easily see that disclosing information regarding a criminal investigation should not take place. So that safeguard is already in this process by allowing the judicial branch to override. Moving further along, right, Article 14, every subject in the state, right, that's every citizen is entitled to a certain remedy by having recourse to the laws for all injuries that he may receive in his person, property, or character, and to obtain right and justice freely. I would argue that when government gets involved with a family, as much as the goal, and oftentimes the goal is successful, is to eliminate the harm to the child, there is unfortunately some trauma that is introduced both to the individual, to the family, and to the child. And our goal as government should be to minimize that trauma and to only do that when such trauma is less than the trauma they're currently residing in terms of their current circumstances. And then lastly, the rights of the accused, right, halfway down through that amendment, right, no subject shall be arrested, imprisoned, despoiled, or deprived of his property, immunities, or privileges, right, without access to that information. And again, right, until the same is fully and plainly and substantially and formally described to him or her, I guess. So my point is, the Constitution is pretty clear that any information that is important to an individual who might be seeing some level of either civil or criminal prosecution, it should be described to them. And while the department can collect that information, and they often act as the prosecutor in some of these civil cases, they also end up being the judge on whether the information should be disclosed. And in keeping with the rest of our due process laws, and we typically have another branch just review that for checks and balances. So this is a minor change to the law to make sure the appropriate checks and balances are in place. And the judges would be allowed, if there's any potential harm to a child, right, or potential thereof, or would result in harm to a child, that they could then easily say, no, there's an active criminal investigation going on and we need to withhold this information. And that would be my testimony.
From the committee, Senator Adams.
Thank you, Madam Chair, and thank you for taking my question. I see where there's the balancing test that will be done it's under the existing law as well. Was there any talk, if the court has to make that finding, any talk about the burden of proof, whether it be, reasonable belief, more likely, presumption of the evidence, clearing
I
convincing?
did not, so I was duly booked during the House hearing on this. I don't know whether that came up in any of the subsequent discussions after I introduced the bill. But it is a good point to raise, right? What is that appropriate burden? It's not here in terms of an evidentiary standard. It's not in current statute at all. And that would be a good introduction.
Follow up? And if there was to be a evidentiary burden, we'll say, whether it's clear and convincing, preponderance of the evidence, any suggestion on what that would be?
So, in this case, I'm the engineer and you're the attorney. I'm not sure what the appropriate, right? Probably reasonable doubt or there's a reasonable suspicion is the level that comes to mind that but maybe it's greater than that. And right, most of these are civil, not criminal in nature. So for some of the civil, like education neglect would probably be prosecuted as a civil issue versus a criminal issue. So I'll leave it up to you in terms of what is the appropriate standard. It needs to be some level of, there's some reasonable certainty.
Thank you.
Are there any further questions? Okay, seeing none, thank you, Representative. The chair will call Beth Markinson. I'm sorry about butchering that. I apologize.
That is fine, Madam Chair. It's Margison. I don't have very clear handwriting, so it's really my fault. So my name is Beth Margison. I am the legislative liaison for DCYF. I work for Joe Ripsum. And the division would like to provide some information to the committee on this bill. So the way the system currently works is that the commissioner designates his responsibilities to find whether or not there's harm to the child from disclosure of records to each district office's supervisor. And the reason that we don't provide records is for when there is harm to the child, and that means when our assessment is still open, and or whether there is concurrent criminal investigation into the same nucleus of facts that gave rise to our assessment. So, but in general, we regularly release records. Once it has been determined that there is no harm to the child for those reasons, then we do release the records to the parents, to anybody else who is allowed it under 170 G8A. I will say the division has a backlog of records requests. It is something that bothers us tremendously. We have been trying to get a records request unit funded so that we can more quickly furnish records to people who request them. And so we have not been able to get that through, and we do have a backlog. But that said, we do release records when the designee has decided that there is no longer harm to the child. So I think that, if this were to pass, you would have a problem with our records releases would be backlogged even more. There would probably be a glut in the judiciary. I'll let the judiciary speak to that. So anyway, this is just information that we want to provide the committee in your determinations on this bill. And if you have any questions, I'd be happy to answer them.
Thank you very much for your testimony. Are there any questions from the committee? Senator Abbas.
Thank you. The same question I have for the last witness. I don't know if there's any opinion on a potential burden of proof if there were to be one.
I don't know. It's not our bill. I don't know what kind of burden of proof would be required in court.
Thank you.
Okay, are there any further questions? Seeing none, thank you very much for your testimony.
Okay,
Are
thank you.
there any other members of the public that would like to speak to House Bill 497? Okay, seeing none, we're going to close the public hearing. There we go. Okay, time is it? We've got 4 minutes. Okay. The committee will be in recess for 5 minutes.
Good afternoon, Madam Chair, Senator Darrell Abbas, District 22. I do know that the prime sponsor had a professional obligation that prevented him from being here today, so I ask you not hold that against the bill itself for the prime sponsor not being here. But anyway, I'm offering no opinion on the bill, otherwise I'm just introducing it as a courtesy. Thank you.
Committee. Thank you. My name is Lisa Dekatowski, and I am the Bureau Chief with the Bureau of Child Support Services with the New Hampshire Department of Health and Human Services Division of Economic Stability. As mentioned, here with me today is Matthew Hayes, Legislative Liaison and Staff Attorney for the Bureau of Child Support Services. And thank you for giving us the opportunity to speak about House Bill 583. We appreciate your time. We wanted to provide you with some information. As the committee may already be, committee knows, the Department of Health and Human Services, through the Bureau of Child Support Services, administers the state's child support program as established by the Title 4D of the Social Security Act of 1975. And House Bill, the Bureau of Child Support Services only a portion of the families here in New Hampshire who apply for and access our services. But to administer the child support program, we understand that House Bill 583 seeks to amend a portion of the termination of child support criteria and provisions as it was amended in the House. So while the department and the Bureau acknowledges that changing these requirements is certainly, for the purposes of child support, is certainly a policy decision, the Bureau does have some oppositions to certain components of this bill that we wanted to bring to the committee's attention. So in essence, this amendment states what the law currently says, but in a more complex way. The current law on its face is fairly simple. The child support shall end at age 18 unless the child is still in high school. So House Bill 583 as amended adds an additional component to that portion of the statute where it would ultimately cap support for families if a dependent is still enrolled as a full-time student but has not graduated high school until they are 19 years of age and 2 months. So this will only serve to limit the child support available to families that may very well have otherwise been available under the current law. And the more complicated that these provisions become in the statute, it may be more challenging for us to explain to families and more difficult for us to enforce and accurately track proper dates for termination of support. There are additional provisions that were added to the amendment that would extend support to age 22 if a child was enrolled in a program approved by the State Board of Education when a child had a disability and support had been extended from what the statute originally states at age 21. The Bureau doesn't take a position on that. However, specifically on line 7, there is terminology in the language, use the term benefits, which could be inconsistent with what support may be considered. So those terminologies don't really align and consistent with the subject matter. Certainly, if this bill were to pass, there would be costs associated to the department. And the Bureau would be required or would need to consider looking at changing policies, procedures, forms, systems updates to our case management program, to be able to continue for us to fulfill our statutory duty to enforce child support orders for those families that we are currently serving. Certainly that would be likely a one-time cost to the department, and there would be some considerable time involved in that with training and ensuring that we had all the appropriate provisions and policies in place. However, there were no appropriations allocated in this bill for these costs on behalf of the department. So one last point that we would like to make to the committee for consideration is that this bill does not address whether these provisions would be applied retroactively to existing orders for child support. So, there are, perhaps thousands of child support orders currently in existence, both being enforced through our Bureau and privately enforced between parties. So we certainly would, there doesn't seem to be any provision within the amendment that speaks to whether changing this law, how that would affect the orders that are currently in place, and whether or not that would in fact constitute a substantial change in circumstances, which would again put heavy, which would rely for resources for the Bureau to be able to address those orders. Again, as I stated earlier, we are here to provide some of the areas in which we think may be problematic for the department and for the families that we serve. And we certainly thank you for your time and giving us the opportunity to speak. And we would be happy to provide any further information or answer any questions that the committee may have.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much.
Thank you, Madam Chair.
Okay, are there any other member of the public who would like to speak to House Bill 583? Okay, seeing none, we'll close the public hearing, and the committee will be in recess for 5 minutes.
Yeah, thank you, Madam Chair, members of the committee. I'm here in strong support of HB 68. As you noted, Madam Chair, this bill was originally introduced by Representative Edwards, I believe if I remember correctly, at the request of a constituent who thought it would be an appropriate bill to introduce. When it was first introduced, we held a hearing in the House, and there were a number of concerns raised about the original terms of the proposal. And so fortunately, one of the witnesses who was testifying and raising the concerns was Attorney Elise Salak of the Soloway office here in Concord. And she volunteered very graciously. She's a trust and estates expert. She volunteered. There apparently are a group of probate, trust and estate lawyers who were aware of the legislation, and they agreed to meet and basically propose an amendment that would address the various concerns they had. And they did that, and that is reflected. I then drafted the amendment, which is now the bill that passed, incorporating literally word for word, all of the bill as they proposed it, making the changes that they suggested. Attorney Salak then came to our executive session on the bill and kind of went over the various issues that she had, the changes that they had made, issues that they had, was available to answer questions. Some members of the committee had questions, which she answered. It was obvious that that group had put in a lot of time on the bill. And so we were very satisfied. The committee, the vote, I think, in the committee was 17-3 or something like that, supporting it. And it passed, if I recall, I think it passed on a voice vote in the House, because there was really no real controversy about it. So 29 states have adopted the Uniform Real Property Transfer and Death Act. It basically is designed to allow people to make a transfer of real estate that'll take effect at death without having to kind of go through it, incur the expense of having a will. But it does contain, as you'll see if you read through, it does contain a number of safeguards to be sure that if there's any hanky panky, so to speak, that goes on, that there are provisions that allow the deed can be revoked in the manner that's provided in the bill, even after the death of the person who makes the will. If there's some question that there was some undue influence or fraud or something like that, there's an opportunity to go to the Superior Court to challenge that. So it really seems like it kind of covers all the bases. I'm happy to answer any questions, but I think it is a really good proposal, and I hope that the Senate will agree.
Thank you very much for your testimony, Representative Lynn. Are there any questions from the committee? Seeing none?
Thank you very much.
Well, I'm speaking on behalf of the three who voted against it, and that is true. It was 17 to, so I'm Representative Timothy Horrigan from Stratford County District 10. So I was one of the three who voted against it in committee and did go to a voice vote. That was on a busy day, so that didn't seem worth fighting it, but I thought I'd show up today. I still have misgivings about it. I think there's still a number of problems with it, including the basic problem, the way it's designed. Well, first of all, the other interested parties may not even know this deed exists, even though it's recorded down at the Registry of Deeds. Not everybody knows. Not everybody involved will think to do that, and that's not necessarily a simple thing if you don't know how to do it. It also allows you to transfer the beneficiary really without the beneficiary's consent, and that can be problematic if there are a number of contingencies they go through in the bill, but there's still a lot of problems that can arise, especially if the beneficiary isn't prepared to take the property. And the idea is this avoids the expense of a will and also the expense of setting up a trust, which is what many people do, including including in my own family when my parents realized they weren't going to live forever. And in fact, my father did die shortly after not long after we set up all the trusts. I think it's not expensive, but I think it's usually probably good. Usually, it's money well spent. I think in the vast majority of cases, just because there's all kinds of issues that the lawyer, because they deal with this all the time, because they're more objective that maybe other, just you yourself or your family members and so forth might not think of. So I think so. It's probably, even though I actually don't have a will, but it's probably a good idea to go to the expense of setting one up. And I think it's not that expensive, and especially, I'm not sure how it is in all the other 29 states, but in this state, real estate prices are extraordinarily expensive. So this is almost always going to involve an asset that's extremely valuable. So it's probably a false economy not to spend a few $1,000, to pay a professional to, get the arrangement right. And, instead of using this canned procedure, which I think is something that could this looks like something that could come back and bite you if you do it wrong. So that's, this is the other thing I'll say, this is it's a uniform law commission. I believe that's the name of it, proposed it. And so this is something that, future Senate and House Judiciary committees can look at, even if you're not satisfied with the current version of it. And I'm not satisfied it. So that's why I was one of the 3 naysayers in committee. That's why I shouted nay instead of yay when it was one of the many bills we did that day. And that's sort of why I'm just taking a couple of minutes off from the budget hearing to come downstairs and tell you people to look at this more closely. And I think I don't think this is ready, even though there's a lot of enthusiasm for it on our side of the wall. I just personally don't share my colleagues' belief that this is something that's ready to pass. So that's why I'm urging you to not vote for it. So obviously I'm going up against my chair, who's also a former Supreme Court justice, so I probably didn't make as good a case as he did, but I figured it's worth a few minutes to come down and testify anyway. So thanks.
Thank you very much for your testimony, Representative. Are there any questions from the committee? Seeing none, thank you.
Thanks.
The chair will call Pamela Newkirk.
Thank you. My name is Pam Newkirk. I'm an attorney in Bedford, New Hampshire, and I'm one of the, I don't really want to call it a member, of the group that Elise Salick, that I always call him Judge Lynn, Representative Lynn, referred to, the T&E committee. And just to give you a little background, as a group, of attorneys, we monitor all of the legislation that comes up here in Concord that concerns any matters that involve trusts or estates, or in this case, a deed that's payable or that's transferable upon death. So things that affect our clients. We're not an official committee of the Bar Association. We just have an interest in weighing in on these bills as they come up, so that we can provide some guidance to the legislators that are considering those bills. I would like to first address the comment by Representative Horrigan that a deed may pass without the consent of a beneficiary. New Hampshire does have a disclaimer statute, and an interest that's passed upon death can be disclaimed pursuant to that statute. So I don't think that should be a concern. The other issue is, the alternative for some people to do a will and pass their property via will rather than by a deed that transfers upon death. I have a couple of comments about that. One is, we have bank accounts that are payable upon death, and that's commonly used as a tool. We have property that passes as joint tenancy with rights of survivorship that doesn't require probate. This is just another tool to be added to the toolbox so that people can pass their property without having to go through the time and the expense of probate. There are some filing fees associated with probate. There are technical requirements that sometimes people are frustrated with that require them to go to an attorney to assist them with the probate process. In addition to that, despite all of the greatest efforts of the circuit court administrative judge King and the courts and the clerks, it is a lengthy process because they, like the rest of us, are all understaffed. And the delays associated with having to go through probate in order to make a relatively simple transfer of your real property upon death should not be a requirement. So those are my comments to the comments that were made in opposition. If anybody has any questions, I'd be happy to ask them because we did spend a lot of time considering this legislation.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you. Are there any other members of the public that would like to speak to House Bill 68? Seeing none, we'll close the public hearing. And, okay, we got 3 minutes. Open the public hearing on House Bill 135 and recognize the prime sponsor, Representative Schultz.
Thank you, Madam Chair. It's an honor to be here. I am at the tail end of a cold, so out of an abundance of caution, I'm going to leave my mask on for everyone else's health. So don't hold it against me if that is concerning. I hope people take it in the right spirit. It is an honor to bring this bill forward today, ban on no-knock warrants. It was inspired originally by the Black Lives Matter movement and some very high-profile incidents. I'm from Louisville originally, where Breonna Taylor died in unfortunate circumstances. But that was just one of a number of instances nationally. And gratefully, we haven't had an incident like that I know of here. But why wait? There is no law in place in New Hampshire defining what a no-knock warrant is. I believe the bipartisan amendment to the original bill is good. It puts the language in a way that will help define what a no-knock warrant is, as well as address some concerns that through compromise seemed like the best way to go. And I very much appreciate our House Chair for working so diligently on this and making it a bipartisan effort. There are three quick things I just want to say. I know that at one point law enforcement opposed the original bill, and obviously they want all the tools in the toolbox they can have, but it is incumbent upon us to define the boundaries and the policy around that. And I do believe that this is in the interest of not just the safety of folks in the residences that are where the warrants are being served, but also for the safety of law enforcement, which gets to my final point. We are a state with a high amount of gun ownership, regardless of your views on that. I think, certainly folks who own a gun for safety, I'm mindful that that creates also a dilemma. And that through a reasonable process of a knock and announce process, that this improves the safety for everybody. So I do urge support of the amended bill. And actually, since that's now completely the bill, I do think our chair is probably best to address the details of that, but I'm still happy to take questions. Thank you very much for your testimony, Representative. Are there any questions? Seeing none, thank you very much. Great, thank you all.
Thank you, Senator Carson, members of the committee. My name is Representative Terry Roy. I'm the chairman of the Criminal Justice Committee in the House. I represent Rockingham 32. This bill came to us and it purported or sought to totally ban no-knock warrants in the state of New Hampshire. There has indeed been a public concern nationwide about the use of no-knock warrants. It is in the public conscious at the moment, and they are concerned about it. So I looked at it. At the same time, we need to balance the ability occasionally, and I stress occasionally, of law enforcement to have to use these type of warrants for their safety or the safety of someone who's in the house at the time they need to execute the warrant. So in this amendment, I tried to strike a balancing act, and I used as a model the current Department of Justice as issued under President Biden, what he wants them to do on no-knock warrants under the Attorney General. So that amendment that you see that is now the bill is actually almost verbatim copied from the current Department of Justice. However, I tailored it for New Hampshire. So just really quickly for the rundown, before a no-knock warrant can be sought by a police department, they would need the permission of their agency head. If that's a state police, it would be the colonel or his designee. A local police department or a sheriff's office would be the sheriff or the chief. If circumstances arise on the scene that exigency, they need a no-knock warrant, they can get one, but they have to immediately notify their chief law enforcement officer. If they got a no-knock warrant based on certain conditions that they believed were going to be present at the time, when they got there to execute the warrant, if they were no longer present, they had to revert back to a knock and announce warrant. And the only thing that is banned is no-knock warrants for evidence preservation. It used to be many years ago, the policy would be that if someone were dealing drugs and they kept them right near the toilet so that when they heard police open up, they'd dump them all in the toilet. So police back in the 90s would get warrants for that purpose, no knock, so they could go in quick and preserve the evidence. That's not the policy of anywhere, as far as I know, in the state of New Hampshire. These warrants are used so rarely that this bill isn't almost needed, but sometimes for the purposes of the public's benefit, we need to put these things in place so they know that we're cognizant and we're watching out for their interests. So having said that, they can obtain a warrant to preserve evidence only if the evidence is related to something that would involve a potential loss of life. For example, if there was evidence on a computer where a missing person might be being held, or evidence of a pending terrorist attack, where they needed to get that before it could be destroyed. But to get one of those warrants, they would need to get permission from the district attorney or the attorney general in advance. So we put some guardrails in place that, frankly, I believe the police are probably already following, but we're codifying it for the benefit of the public and everyone else. And I think that's about all that we did. So I'm happy to take any questions.
Thank you, Madam Chair. Thank you, Representative. So you had mentioned something that had come from the federal AG. Was that a guidance document? Can you just tell us more about that document?
Sure. What I did is I went to the U.S. Department of Justice website where they were happily have their you can actually search their guidelines for no-knock search warrants as written by the Attorney General. So I took that, I looked at those, and I said, well, this is basically achieving what we want. It's no longer practice or acceptable for them to get warrants to preserve evidence. It's always keyed on officer safety or someone else who may be in the house. Another example might be, and I didn't bring this up, in a domestic situation where the husband says, if you ever call the cops on me, you're dead. Well, they may need to do a no-knock to get in there to protect her before he could hurt her. That would be an example of a safety incident. Senator Abbott, you sure you don't have a question? Thank you.
Okay, next, we're going to go to Paul Halverson.
Afternoon, Senator Carson, committee members. My name is Paul Halverson. I'm the Merrimack County Attorney. Yeah, I've been practicing criminal law for about 20 years. I just passed 20 years as a prosecutor. I practiced prior to that as a defense attorney for several years. And by way of background, I want to let you know that I have never seen in my memory, I don't believe I've ever seen any no-knock warrant in New Hampshire. I talked to several of the attorneys in my office today before I came over to testify, and none of them could remember the execution of a no-knock warrant in New Hampshire. I'll defer to the law enforcement professionals behind me to address the tactical issues and the need for a no-knock warrant. I came today to comment on some of the language, excuse me, in the bill that I found a little bit problematic. Should you adopt this bill, I would ask that you at least look at changing some of the terminology within the bill. You have in front of you a document that I handed out. There's highlighted portions within the bill, as well as footnotes referring to those highlighted portions. I'll walk through it, and please interrupt me as we go along, should you have any questions as we go along. Looking at page 204, paragraph 2A, that highlighted section talks about any law enforcement officer involved in executing a search warrant. The following sentence talks about an executing officer. These two sentences appear to talk about two different circumstances of executing a warrant. The first one appears to talk about an empty building or an empty area. The second one seems to refer to an area that has somebody in it because it has an explanation of why the police are there to execute the warrant. The term any law enforcement officer in the first sentence needs to provide audible notice can be read, and I talked to several attorneys who read it the same way, that every officer has to announce their intent there. It seems that the use of the executing officer or the lead officer may be able to do that rather than risk every officer having to accomplish that. The word uniformed in the second highlighted line. Many search warrants, and I'll defer to police professionals behind me to talk about the execution. Many search warrants may involve the use of a detective who's in plain clothes. It may involve the use of a undercover agent who may also be in plain clothes. They may be dressed in a vest or a blazer that is not a complete uniform. By dropping out the word uniform, if you consider doing that, you're still left with recognizable and identifiable as a law enforcement officer, however that may be. Badge around the neck, jacket with a marking, items such as that. I think you wind up at the same area without having to have uniformed officers present for each and every search warrant. And I'll defer to the remainder of my footnotes to that issue. Do you have any questions off of that issue? On the second page, there's a footnote. First footnote has to do with his or her. There are a couple places in the recommended statute that applies that. Other refers to their. It's a stylistic issue, but that maybe want to be changed to just reflecting their. Continuing on the second page, to talk about the head prosecutor for a jurisdiction. In New Hampshire, it's conceivable to have a police prosecutor as the head prosecutor for a small jurisdiction. When we look at possibilities within this statute, it's totally possible that the police chief, the chief law enforcement officer, may be going to a subordinate for notification of a no-knock warrant, for approval of a no-knock warrant for a police prosecutor or an attorney prosecutor who works for that police department. So one of the considerations that I put before you is to address that by changing that to county attorney for their jurisdiction, because I think the intent, as I read this statute, has to do with vertical supervision, not lateral supervision that may fall within a police department. Down the bottom of page 3 or 4, talks about the district or county attorney or attorney general or their designee. New Hampshire doesn't use the phrase district attorney anywhere. It can be confusing if it remains in the statute. So for consideration, removing the word district or, the words district or may be appropriate. Several attorneys read county attorney, attorney general, or their designee as mandating a report to both the county attorney and the attorney general. If it's the intent for vertical supervision to occur either at the county attorney level or the attorney general's office level, perhaps inserting the word or between county attorney and attorney general may be appropriate. On page 404, again, his or her stylistic, again, district or county attorney, district or removal may be warranted, and inserting the word or between a county attorney or attorney general. In paragraph B, they talk about a premises. A premises is defined in some law dictionaries as a building, adjacent buildings, and the curtilage around those buildings. One thing to remember is not everyone lives in a building. There are tents. There are people who live in campers, trailers, cars. A recommendation may be, for consideration, changing the words a premise to an area. I believe that adding the term an area in place of a premise would therefore default to the search warrant and the parameters of the search warrant that is issued by a neutral and detached magistrate. And I believe it takes away the ambiguity of a premise. The one thing I would consider adding as a new paragraph would be, should this be adopted by the Senate and the legislature, is that there may be a need or a desire to have a common procedure for doing this statewide. So an added paragraph that I would recommend would be that the Attorney General's office issue guidance that's followed statewide to ensure that, for example, a drug task force, which had multi-agency individuals in it, is following the same procedure in Nashua as it would in Franklin. And I think that that guidance from the Attorney General's office would be beneficial. That summarizes my commentary. I'll defer to the footnotes, and I'll certainly answer any questions that anyone may have.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Seeing none, thank you very much.
Very good, thank you.
The chair will call Major Joseph Ebert.
Good afternoon, Madam Chairwoman, members of the committee. My name is Joseph Ebert. It's E-B-E-R-T, and I am a major with the State Police. I oversee the Investigative Services Bureau, which in large part is the state police detectives. So I wanted to start by thanking Chairman Roy and his committee. We made several recommendations while this was before his committee, and many of which have been incorporated into this amendment. Having said that, if I hope that the lines match up with the bill that you have in front of you, but if I could direct your attention to line 17, Attorney Halverson addressed this, or at least I think he mentioned it, and I wanted to make sure that I was clear on our concern about it. It talks about the person giving notice to either the person to be searched or the person in control of the premises to be searched. Our concern with this is if there is no one inside the premises to be searched, or if the person inside does not respond, you're left at kind of a stalemate, or at least that's the way we perceive it, as you're left at a stalemate as to what happens now if you're not able to notify and have some acknowledgement that that person inside has heard your notification. The second item is line 25. And I think this is just an inadvertent omission, but where it talks about municipal, the head of municipal law enforcement agencies, it also talks about his or her designee. When it talks about the head of a state law enforcement agency, it doesn't give that relief. And as much as I know as our colonel is dedicated, I think he would appreciate the ability to designate somebody to also be able to consult on these type of warrants. And lastly, I think this is, I was just having a conversation before I came up. I think this is implied in the writing of this amendment, but I wanted to outline it as a concern that we have. If you were to make an entry, an exigent entry, based on thinking that there was evidence stored on, for the purpose of the example, we'll say a laptop, because you had information to lead you to believe that the location of a kidnapped individual was on a laptop. You make entry into that residence where there is a trove of evidence inside, but what's not there is the laptop. You made your entry based on that. Is there an argument to be made by defense that, well, you made your entry based on a failed premise? So at least I wanted to present on behalf of the division the notion of some type of a good faith exception where you are acting on, I expect that you would have to account for, well, why did you think this? What led you to believe that this evidence was inside? I think that's a rare occasion that such a thing would occur. And I do think that the intent of the amendment would cover that. Having said that, I wanted to outline that specifically. That's all I have. If you have any questions, I'm happy to answer them.
Thank you very much for your testimony this afternoon, Major. Are there any questions from the committee? Senator Abbas.
Thank you, Madam Chair. Thank you for taking my question. Is there any policy specifically with the state police of when or when not a no-knock warrant would be used? It's not in statute?
Yeah, so I appreciate the question very much. So we did research during the course of the House hearing on this. And though there are policies that govern when certain tactics are used, we do not have a no-knock warrant policy. We do have policies that govern our tactical team. We have policies that govern risk mitigation. We have documents, for example, a risk assessment, which you put a number value on the individual who may or may not, or the structure that you may be entering. So there are a number of items that we employ prior to a no-knock warrant. And if your question is, well, how many no-knock warrants does the state do in the course of a year? When I checked with the tactical team commander, he was not able to remember or recall one that he had served.
Okay. Any other questions? Seeing none, thank you very much.
Thank you for the time.
The chair will call Sergeant Mark Harrington. Good afternoon.
Senator Carson, Chairman of the committee. My name is Mark Harrington. I'm a sergeant with the Manchester Police Department. I've been a resident of the state of New Hampshire. There we go. And a police officer here for the last 15 years. I currently serve as a first line supervisor on the 4 to 12 shift in our patrol division. And I've also been a member of the department SWAT team for the last 13 years, the last 3 of which have been as a team leader. I'd like to thank you for the opportunity to speak before you today in opposition of House Bill 135 on behalf of my department and also the New Hampshire Chiefs Association. I'm going to speak about no-knock warrants and knock and announce warrants, both of which I have extensive personal experience with. Unfortunately, no-knock warrants have recently gained negative national attention due to a few tragic incidents that occurred outside of the state of New Hampshire. A no-knock warrant is a search warrant authorizing highly trained police officers to enter an identified premise without first knocking and announcing their presence and purpose. No-knock warrants are intelligence-driven, meaning that there's an investigation that's led to an extensive research, surveillance, and intelligence that has been obtained requiring the no-knock warrant. This information usually identifies that the suspect is likely to be armed with a deadly weapon, has made statements of resistance, has fortified the premise, and has surveillance systems or aggressive animals. No-knock warrants provide police officers with inner structural control while clearly identifying themselves, which is a key advantage when executing these warrants. This tactic is used with the intent of keeping the suspect from arming themselves, harming others within the premise, or fleeing upon police arrival. Upon executing a no-knock warrant, loud PA announcements are immediately made by law enforcement, clearly identifying themselves as police to the suspect and the surrounding community. No-knock warrants are highly effective and when executed properly provide the highest level of safety to the public, officers, and to the suspects. Although a no-knock warrant allows for officers to enter a premise and execute a warrant, it has more complex tactics and decision-making involved. Depending on the intelligence gathered, law enforcement may utilize a breach and hold tactic, a first room entry, or potentially a fluid dynamic entry. The key point is that law enforcement has options depending on the situation, intelligence, and the safety concerns. A knock and announce warrant is a search warrant requiring police officers to first knock and announce their presence and purpose prior to entering the premise. A key issue with a knock and announce warrant is that it gives the suspect time to arm and potentially attack police, as was seen in Philadelphia just a short while back, where 3 Philadelphia SWAT officers were shot through the front door and the window of the residence by the suspect. It allows suspects time to potentially take innocent victims inside the premise hostage or inflict injury upon themselves or a third party. If HB 135 were to pass, officers would not have the option to execute a no-knock search warrant and would be held to a knock and announce warrant only. In New Hampshire, tactical teams across the state take great pride in their investigations, preparation, and execution of these warrants. I can speak from personal experience when I say I have seen the benefits of a no-knock warrant in which a suspect has attempted to arm themselves upon police arrival. If a no-knock warrant had been executed, the resulting investigation could have ended with a lethal engagement instead of a peaceful surrender. In closing, I thank you. I ask that you find House Bill 135 inexpedient to legislate, and I thank you for your consideration.
Thank you very much for your testimony. Are there any questions? Senator Whitley?
Thank you, Madam Chair. Thanks for taking my question, Sergeant.
Sure.
So I'm wondering if you had thoughts specifically about the amendment that the House worked on. So it sounds like it's a more nuanced approach rather than a complete ban.
Well, I know that it was reviewed, and in totality, we have opposition to the bill in general, to the totality of the bill. with the amendment is already situated within.
Follow-up?
We heard some testimony before that, you know, these don't really happen in New Hampshire, and I'm wondering if you could share with the committee whether this happens in New Hampshire or in Manchester and how many.
Well, they absolutely happen in Manchester. The exact number, I would have to research a little bit better for you. Like I said, I have been on the team for 13 years. I would be comfortable in saying we probably execute in the last 13 years between 15 and 30 each year of no-knock warrants. We do work in conjunction with federal entities, so we do occasionally get federal warrants that are served. But in general, the majority of what we are given to work with are with no-knock warrants. And then from there, as we press forward and put together our operations plan and how we're going to actually execute at the time of the execution, it is highly dependent on things that were discussed, like by the major, the threat assessment that's done, surveillance that's done, intelligence given that we might get from debriefs of people who have been inside or had previously lived there. I really can't explain how much work truly goes into the preparation before the execution once the search warrant is actually granted. And that's in a perfect world when we have time. You know, obviously there are more exigent circumstances that come up, but if this is a planned execution, you know, there are literally hundreds of man hours that go into the intelligence driven side of it and then the preparation after that. So it is quite a process, but to go back to your original question, yeah, I would say it's comfortably between 15 and 30 each year.
Last follow-up.
Follow-up?
So, considering that, you know, it does happen and, you know, 15 to 30 a year, does Manchester have a policy about no-knock warrants that you could share with the committee?
I don't believe that we do have an exact no-knock warrant policy, but like was previously stated, we obviously have SOPs directing the tactical team and the preparation of the operation, but nothing specific to the no-knock warrant itself.
Okay, Senator Abbas.
Thank you, Madam Chair, and thank you for taking my question.
Yes, sir.
You mentioned that some of the no-knock warrants that you participate or have participated in executing were warrants from the federal government, and you're kind of working in collaboration with federal officers.
Yes, sir.
What type of scenarios are you encountering where the Manchester Police Department's working with federal officers?
Well, we have officers, detectives on our department that work as task force officers with the FBI, with DEA. So, you know, those guys are working as part of the DEA or the FBI teams and assist in their investigations. And then, obviously, that investigation would come into our municipality, which would bring us into use.
Follow-up?
Thank you. And we talking cases like human trafficking cases? I mean, what's the type of crimes that you're working with?
Yeah, and
federal officers.
to answer your question, sir, yes, there have been human trafficking, drug and weapon sales, stuff of that nature.
Thank you.
Okay, are there any further questions? Seeing none, thank you very much, Sergeant.
Yes, ma'am. Thank you.
The chair will call Joseph Lacaze and Gilles Bissonnette. Good afternoon, gentlemen.
Good afternoon, sir. I will be testifying.
Okay. Turn on your microphone.
Is it on now? There we go. Okay. I will be testifying in support of HB 135 on behalf of the ACLU and the New Hampshire community. We've heard a lot of information today, so I don't want to regale that. But one of the concerns that I wanted to just bring up is that there is enough data in public incidents to show that no-knock warrants do pose a risk, not only to community members, but as well as police officers as well. I would like to be very crystal clear. We are not in any way trying to say that police officers or any member of law enforcement should not have safety protocols or measures in place to safeguard themselves when executing their job. There's been 81 civilian deaths and 13 police officers across the nation during the use of no-knock warrants. And if we go all the way back, we can start at the 70s and go all the way up to the most recent with the Breonna Taylor situation. And when we look at that, when we look past the Breonna Taylor, we look at some of the other factors of that situation. One being that not only was she shot 5 times during that situation because there was no protocols in place for no-knock warrants being used, her boyfriend returned fire at police officers because he did not know who was coming into the house and thought it was her ex-boyfriend breaking into her apartment and returned fire. And that individual was not charged. He wasn't charged, and he didn't because he didn't know. It wasn't announced, and he was allowed to. New Hampshire has a gun culture. We know that. We have stand your ground in New Hampshire, and this poses a risk. Can we just imagine if the officers are not identifying themselves in situations, especially in a situation where a person is indirectly connected to a situation like Breonna Taylor, who was not the actual subject of the search, that poses a risk. And all we're trying to do is create a structure, a safeguard around that for New Hampshire residents. Some of the testimony that you heard earlier, Attorney Bissonnette is going to share some thoughts on, but I am happy to answer any questions that we have on this matter after.
Thank you.
Thank you, Madam Chair, members of the committee. I just want to address a few points and just be clear at the outset that this is not a ban on no-knock warrants outright. Rather, in my view, frankly, this is a very modest and reasonable proposal for New Hampshire that, in fact, I think adopts the recommendation of the New Hampshire Attorney General and Department of Safety, and I'll get to that, but also, frankly, simply memorializes in New Hampshire law many of the limitations that exist for no-knock warrants that the federal law enforcement are currently using. So I want to be very clear. And in fact, I actually think this bill goes even further in allowing no-knock warrants than federal regulation. So it's even more permissive. And I just want to walk the committee through that. But just at the outset, Sergeant Harrington testified almost, I think, assuming that this is an outright ban, which it, of course, is not. The House changed the bill to allow for many criteria in which these no-knock warrants could occur. 4 states actually currently ban no-knock warrants. That's not what this bill does. So what I have done for the committee is attached as Exhibit A to my written testimony the federal no-knock policy, which was issued on September 13th, 2021 by the Department of Justice. And I just think that's an important reference point as the committee is kind of looking at that policy and trying to mirror it to what this bill is trying to accomplish. Under the federal policy, no-knock warrants can generally only be used when an announced entry would pose an imminent threat of physical violence to the agent or other person. That is really what this bill does. It just takes that federal policy and enshrines it in New Hampshire law. So when Manchester police officers are executing no-knock warrants with federal agents, those are the rules that the federal agents that they're with need to follow. So if they're doing something together, it doesn't seem to me at least all that problematic, particularly if there's a joint effort that the Manchester officers have to follow the same rules. I think if this can work for FBI agents, FBI SWAT officials, I think it could work for New Hampshire officials. And this, in fact, was the testimony that was presented before the House Criminal Justice Committee back on February 9th. The original bill was a total ban, which, we support, but clearly that wasn't where the committee was. And Associate Attorney General Jeff Strelzin testified to the committee. We would suggest that if you consider passing this bill, you consider using the same exception that the U.S. Department of Justice has put in place, namely the exception allowing for no-knock warrants where an announced entry would pose an imminent threat of physical violence to the agent or another person. That is what this bill does. Chairman Roy took that recommendation and said, we think that's a good recommendation. That's what the new version of this bill would be. But this bill goes even further in allowing no-knock warrants than under federal policy, and that is reflected under page 2, lines 12 to 19. And it provides another basis to allow no-knock warrants where there are exceptional circumstances. So I just want to flag, this is not a ban. It is very permissive in a unique set of circumstances. Why should we memorialize this in a statute? Because right now, the departments that do this or want to maintain the ability to do this, it doesn't seem like they have any written policies in place at all on this. The state police doesn't. The Manchester Police Department doesn't, and the Manchester Police Department doesn't, even though in the last 3 years, from 2020 to 2022, they have conducted, based on the documents we received under the Right to Know law, 39 no-knock warrants just during a 3-year period. So I think in the face of all of that, it is very important for the state of New Hampshire and this committee to put some guardrails around this process. That is exactly what this bill does. I want to just get to the 3 technical issues that Major Ebert referenced. I think all of those are solvable in the text, and we are very amenable to the changes that he recommended. That would include on page 1, line 17, with respect to notice when no one's in the house. I think you could just as easily add a sentence that says the requirement of notice shall be deemed satisfied if no one's on the premises. Easy fix. I think that language would resolve that issue. On line 28 on page 1, with respect to the head of the state law enforcement agency, I think you could just say at the end of line 28, the chief law enforcement officer of the specific agency or designee. That would resolve that particular issue. And lastly, with respect to the good faith issue that Major Ebert raised, I think that too could be resolved with a simple fix. Page 2, line 15, where it says an officer believes, an officer in good faith believes. I think that would resolve that issue as well. But we think this is very modest, very reasonable piece of legislation that would be a great first step for New Hampshire in recognizing the issues that Mr. Lacoste has raised. Thank you.
Okay, are there any questions from the committee? No, thank you. Mr. Bissonette, I am going to ask you to repeat the language you suggested. That's on page 1, beginning with the executing officer shall. You said it could be.
Yes, absolutely.
Fast, and I'm like, okay, let me.
No, I know, and I said it really quickly, and I'm doing it on the fly, Madam Chair. But I think, it could be something as simple as this requirement of notice shall be deemed satisfied if no one is on the premises. I think hopefully that would resolve the concerns that have been raised by Major Ebert.
The requirement of notice shall be deemed satisfied if no one is on the premises.
Okay, I just wanted to get that.
Sure. Thank you, Madam Chair. Thank you for considering it. Appreciate it.
Okay. Are there any further questions? Seeing none?
Thank you.
Both very much.
Thank you.
Okay, the chair will hear from Chief Deputy Fisher.
Senator Carson, Chair, members of the committee. My name is Gary Fisher, and I am the Chief Deputy Sheriff for the Hillsborough County Sheriff's Office. I've served in New Hampshire law enforcement for the state of New Hampshire for over 37 years. I'm here to testify in opposition to House Bill 135 FN prohibiting no-knock warrants. Over my 37 years, to put a number, the number of no-knock warrants I've been involved with are slim to none. To give a little bit of a background on a warrant, whether you want to call it a no-knock warrant or a regular search warrant, there's a process that every search warrant goes through, at least with the agency that I'm currently employed with in my previous agency. It's reviewed by a supervisor, it's prepared by someone, reviewed by a supervisor, approved by either legal counsel if there is one, or you heard mention of a police prosecutor, or approved by a police prosecutor, prior to even going before a judge. Once it goes to the judge reviews it with the affiant to tell whether or not he feels that there's probable cause to issue a warrant. When it comes to a no-knock warrant, normally the no-knock warrant, there is some sort of information that is based off of intelligence that's been gathered, whether it's from previous cases involving the individual, surveillance that's been done. There's information in that affidavit requesting a no-knock warrant. The judge can either agree to approve the warrant, or he'll deny the warrant. As far as no-knock goes, he or she may say, no, I will not issue a no-knock warrant and authorize a regular search warrant, where we would have to knock and announce. With that being said, I can think of one case that I was involved with that was a no-knock warrant. Once that no-knock warrant, we entered the building, we immediately notified and told people the police were there and we were executing a search warrant. So the no-knock warrant was used to get into the building. Once we were inside that building, we announced police department search warrant, and we took it from there. I'll go back to a testimony that you heard earlier from, I believe it was the representative from Rockingham. I heard that this was almost isn't needed. I will agree. It is, I will agree to that plus more, that it is not needed. There are fail-safes in place. There's procedures that are in place, and ultimately a judge will decide whether or not a no-knock warrant is issued. Same idea as with a nighttime warrant. The judge has the ultimate decision on a nighttime warrant, whether or not to allow for a warrant to be executed during nighttime hours. In closing, I would just ask that you find this bill as an expedient to legislate, and I'll answer any questions if I can.
Thank you very much for your testimony. Are there any questions? Okay, Senator Abbas, then Senator Whitley.
Thank you, Madam Chair. Thank you for taking my question. I believe your testimony was that if a no-knock warrant is applied for, if that's the case, will the warrant itself specify that it's permitted for a no-knock warrant?
The affidavit would list in there why the agency was requesting a no-knock warrant. The warrant would then be signed off by the judge, allowing for a no-knock warrant. And if the no-knock warrant was not issued, then that would be stricken from the affidavit. Or a notation could be made by the judge, literally in the warrant, that a no-knock warrant was not authorized.
Follow-up?
In the procedure is if the no-knock warrant was not authorized by the judge, would the court still be able to issue a warrant that would require you to knock and announce your presence?
I'm sorry, I didn't hear the whole thing.
In the circumstance where the no-knock warrant was not allowed by the court, or by the judge, is there a procedure in place where the officer can still apply for a warrant that would require you to knock and announce your presence?
The warrant could still be authorized by the judge, but not as a no-knock warrant. It would be issued as a regular search warrant.
Thank you.
Senator Whitley?
Thank you, Madam Chair. Thanks for taking my question. We heard some testimony about how this bill sort of just lines up with what federal law enforcement in the state is already required to do, and in fact, maybe is a little more permissive. So I'm wondering why, it sounds like you believe that New Hampshire-based law enforcement needs a little more permissiveness than federal law enforcement. I'm wondering if you can tell the committee why.
I have not seen the federal guidelines on these, or what the directive was, or to what degree, whether it's guidelines or what it may be. I don't know what those are. I will say that, in my opinion, from what I've heard, we're already doing that. And we've been doing it for years. I know things have happened across the nation that have caused some heat to be brought on this type of a situation. But I think we are already doing these things. I also, the testimony that was given earlier is there's a lot of glitches from what's being presented as far as technical aspects of it. You heard from the county attorney's office that there's some issues with the verbiage that's in there, that the outcome may not be what the desire was, or the desire may not be what I'm sorry, I had it right the first time. The outcome was not what the desire was when this was brought forward. I'm concerned that I don't think it's ready to go forward. And I didn't hear the ACLU's comments as far as the amendments were concerned. I didn't hear all of them, but I thought one of them raised my eyebrows and saying, I don't think that answers the question. And I don't recall which one it was. I don't think it's ready to go forward.
Follow-up?
So assuming we can sort of address the, issues that, I don't remember who, Sergeant Eber raised, or Major Ebert raised. And, you said that it looks like you're just sort of, we're memorializing what you already do. So I'm trying to understand the opposition of memorializing something that you already do. Or that's sort of the practice in New Hampshire already.
It may be memorializing what we already do, but I think it's also tying our hands. And looking at the language that's in there, I believe it is more restrictive by going through either the department head. There is a process in place. Not every chief of police reviews every search warrant that's issued by an agency. Not every deputy chief. It ties the hands. Some of those things, and I heard mention about having it reviewed by the county attorney's office. It takes time to have some of these documents reviewed by the county attorney's office. Sometimes we don't have that time to be able to have it reviewed by the county attorney's office. We do it internally. Our personnel have got years of experience dealing with these situations. We look at them case by case, the intelligence that's gathered, the matrix as far as the dangerousness of the situation that's before us, and then it's taken to a judge, and the judge has the final decision.
Are there any further questions? Seeing none, thank you very much for your testimony.
Thank you.
The chair will call Chief Crawley. Good afternoon, Chief.
Good afternoon. Thank you very much for having me. My name is Tim Crowley. I'm the police chief in the town of Atkinson. I have been for almost 5 years. I'm also the second vice president of the New Hampshire Association of Chiefs of Police, and I'm here to speak in opposition of House Bill 135. No-knock provisions on search warrants are a necessary and not mandatory, but it's a necessary option that law enforcement agencies need to have. It's got to be a tool on the tool belt that you can go back on. In my previous life, I did 35 years in Massachusetts in the city of Lowell. For 13 years, I was on a regional special operations unit SWAT team. Back in the 90s and early 2000s, when you had crack cocaine running the streets of the country and the devastation that was doing, we did dozens of no-knock entries in drug dens that were dealing based on information regarding weapons and hazards to the people around there. So it was an option that we were able to use. There are two things that are important to kind of separate. The tactical aspect of an entry, of when you have a no-knock search warrant in place, the team that's going to do that entry, that's going to make the dynamic entry into a location to secure the people in there, are not there searching for evidence. They're not there executing the search part of the search warrant. Their job is to enter and secure the people in there. Most of the time, and in most cases, they don't get the search warrant. They don't. All they know is that the practice that they do, the drills that we do, the teams that are taught, the officers that are highly skilled that are going to do these entries, know that they have to go in unannounced and secure the people that are inside. In the close to 100 operations that I was involved in as either an operator or a team leader in Middlesex and Essex County, because the team that we were on covered 2 counties and 61 locations in those counties. So we did a lot of search warrants back in that time. The process, the practice, the moves that you make when you go into a place, there's a lot that goes in before you get to the door to go in. Once you're in there, you have one job, is to keep the people that are in there safe, secure them, and wait for the people that are coming from the outside in to do the search. So I know there's a lot of talk about policies regarding execution of no-knock search warrants, but after an officer has the warrant with a no-knock provision, you want the right people that are trained to do that, to make that entry. In New Hampshire, you are way ahead of the curve now. I know from coming from an out-of-state agency and training around the country and taking training sessions around the country, New Hampshire is looked at one of the leaders in law enforcement. The professionalism of this job in New Hampshire is second to none. The certifications and the professional requirements that it takes to get this job, just as a patrol officer working the street, are higher than anybody around here. You already have in place the policies and the legal procedures that dictate how search warrants are issued, reviewed, and the final say is the judge that determines that. I think HB 135 is trying to fix a problem that doesn't exist. You already have in place the regulations and the restrictions that follow that, and that's reviewed by a judge. As far as the execution is done by teams like you heard from Manchester. In all the operations that we did, not one time, hundreds of firearms seized, not one time was there a shot fired. Because if you rely on surprise, assertiveness, and speed, you are entering a place before somebody's perception reaction time can kick in. Take if you're laying in bed tonight and you hear a loud noise. The first thing you're going to do is you're going to wait. You're going to say, what was that? And it's going to take you a few seconds to figure it out. And you're either going to wait for it to happen again or you're going to get up and check it out. In that time frame, in a dynamic entry, in serving a no-knock search warrant, you're already secured. Before anybody can act, before anybody can grab a weapon, before anybody can do any harm. And that's the whole point of it. Again, they're very rare, especially in the state. I know Manchester does a lot of them because of the nature of the business up there. And especially now with the way the drug trade has changed, but also you're dealing with human trafficking cases that you're going to need to make dynamic entries on to save lives or to protect the safety of the people in there. And one thing I want to clarify, because as a trainer, as somebody who takes a lot of pride in this job and what we've done in the past, the Breonna Taylor case is probably one of the main reasons that we're here right now. When you look at the facts and you go and you read the testimony from the grand jury testimony, when you read the intelligence reports, when you read the reports that we're taking from that, there's a couple of things that are very important to understand. The warrant that was executed in the Breonna Taylor case had a no-knock provision that wasn't executed. They didn't enter without announcing. Had they have done that with the size of that apartment, you wouldn't even know who she was. They knocked and announced. He said it. He heard a loud noise. They didn't know what it was, thought it was the ex-boyfriend getting in. So they had time to get out of bed, grab a gun, position themselves in the hallway, and then fire at the first officer coming through the door. He shot first. He shot the first officer coming through the door. Rounds were fired back. Had they executed the no-knock provision on that warrant under a dynamic clearing situation, they would have never gotten out of bed. Looking at the size of that apartment, it's not much bigger than the space that we have right here. That would have done properly. So in closing, I think probably one of the most important things I can say is once you issue a warrant with a no-knock provision, a lot of planning goes into it, hours and hours of surveillance, checking the area out. As you're on your way there, up until the point where you go through that doorway, if something changes, if some situation changes, as was stated by Representative Roy under the federal guidelines, if something changes, doesn't mean you have to execute it that way. Last minute, you constantly evaluating the situation. And just because it says you have a no-knock provision to your search warrant doesn't mean you have to do it. It's just an option and a tool that you can use. And I think it's very important that we make the distinction that no-knock warrants make things safer for people in houses that are having the warrant executed on and the officers that are going in there. That's been my experience, and I know I'm limited to just under 5 years. I'm coming up to 40 years on the job, but in 5 years of New Hampshire law enforcement experience, I can tell you you're way ahead of the curve than you are in a lot of other places in this country, and I don't think this bill is necessary.
Thank you very much for your testimony this afternoon, Chief. Are there any questions for the Chief? Senator Whitley.
Thank you, Madam Chair. Thanks for taking my question. So I want to bring the conversation again back to like the specific version of it, which is, had been amended a lot in the House. So I think the first version of the bill was, there was a complete ban, right? And so there was a lot of work to sort of make it more specific in New Hampshire. And so I'm wondering if, looking at the language of what we have before us, is there, a specific purpose that, you would want to use a no-knock warrant for that's, not allowed under this bill?
Is there a purpose that's not allowed under the
Right.
bill?
So my point is that it's the version that we have before us is very different than the original, right? The original was a ban and it was very limited. And so, your testimony was sort of how important no-knock warrants are, and I hear that. And
Right.
so, but then when I look at the bill, it seems like, well, that's permissible under the bill to use it for these different purposes. So what is What is it not permissible for that's banned under this version that you would think you would need it for?
I just don't like anything that would limit unpredictable things that happen. I think that you can't legislate exactly what's going to happen in an operation, and that you have to, we talked about uniform and how people were dressed, and there's a lot of things like that in there that would need to be changed. But I'm still, after being around a little bit, why it's even on the table when you already have processes and procedures in place to protect the people of New Hampshire before something like this is issued, before a warrant is issued and a judge reviews if you have enough for a no-knock provision. And every circumstance is different. Every incident is different. Every entry that you make is different. Every warrant that you get. And I think you're gonna have 1,000 warrants versus maybe one no-knock along the line, even just doing knock and announce warrants. I think the review and the processes that you have in place are already strong enough that I don't think you need to add to them.
Okay, are there any further questions? Seeing none, thank you very much.
Thank you.
Okay, are there any other member of the public that would like to speak to House Bill 135? Okay. Oh, ma'am, would you come forward, please, and give us your name?
Yes.
Please have a seat.
Yes, ma'am. Thank you. Thank you, everyone, for allowing me to have the time to talk. This isn't easy for me.
Ma'am, I don't want to.
I'm sorry.
Excuse me, we need your name.
Sure. My name is Holly Kucha.
Thank you.
You're welcome, ma'am.
Please continue.
Yes, ma'am. I am a victim. I'm sure those in the room today remember the news reports. It was all over WMUR News 9 on May 28th, 2021. My mother, Marlene Kucha, was murdered by my father, Philip Kucha. He's up at County Corrections. It was sheer horror what I walked into. I had run errands someday. I had approached my parents' home to find the door closed over my mother's bedroom. The light was on, no noise. My father, unfortunately, don't consider him that, told me not to enter the bedroom. I had cared for my mother for 10 years. I have a license in LNA. He had beaten and strangled my mother. Then he beat me and was strangling and assaulting me. I was able to defend myself. I had taken kickboxing through Title Boxing Club for 4 years. So I was able to defend myself. The police, Concord police, entered, but I'm very grateful for the work that they did that unfateful day. They hollered that this is the Concord police, and I felt safe knowing that the police were there and that it would soon be over. I see a grief therapist now every week, Shannon. I've since moved forward. I have a job and my own apartment. I have some good friends. It isn't easy for me, but I would like to thank law enforcement for helping that day. I appreciate that they didn't just barge in like they had to barge in, but they acknowledged their presence, because I was afraid to open the door when I heard footsteps rushing up the stairs, because I was afraid it would be my father going to be entering upon the room again, because he told me he was coming back for me to finish the job. There was abuse in the home over the years. My mother endured abuse while I was growing up. My mother worked very hard. She secured a home the best way she knew how. My grandfather, Alfred Halden, was more of a father to me, and he served as a medic in the Navy over in Guam. So he had quite an extensive background. He was a stern, solemn man, but he was kind and caring at the same time. And for that, I am grateful to have had such a great mentor in my life, and my mother. I will say, though, what I'm disappointed, though, in would be the fact that the police had come numerous of times to the household. The last time, before they took him away, they obtained weapons from the home. That should have been an indication problems were really happening at home. Nights that I spent the night in the home, I would sleep on a futon in the living room with a cast iron skillet underneath my pillow, for fear of not knowing if I would or my mother would wake up the next morning. That's scary. He had outbursts where he would break things in the house. He broke the hinges off from the shed doors. My mother's last words in the hospital, because she had gone in for blood transfusions 3 different times, and I begged the social worker, I begged doctors and nurses to please help us. My mother could not defend herself. And my mother's last words, do we wait until he kills me? 3 weeks later, mother was murdered. But at the same time, I do appreciate what law enforcement, what the city of Concord did for me. And they did a very good job. Those that entered the home, they did a thorough investigation. But I will say, though, that one thing that was very scary was knowing there was one loaded handgun in the home that was unaccounted for, at which point my cousins Laura Bunton and Ronald Courier had been staying at the home at the time, and they were helping out the family. And we begged the police, please don't go. There's one more loaded gun in the home. If he finds it, he will use that gun on all of us. He booby-trapped the home with steak knives. One time, the night before Mother's wrongful death, I had gone to a fitness class and I called home and I said, I'm swinging by Hannaford to pick up food to make dinner that night. Mother and I decided on a vegetable fish stir fry, and my father wanted steak. And I said, that's fine. I'll come back with all the stuff to prepare dinner. I couldn't get in the house. He booby-trapped the house with ice picks at the door. Later that night, he put ice picks beneath our beds. And that was scary. My cousins were not home. They were out of town. They were setting up a trailer down in Epsom at the time after coming back from a camping trip because he had thrown them out of the house. He didn't even want me, his own daughter, in the home. It's not easy to share my story, but I'm grateful to have this opportunity to finally have my story, simply because because there's no actual trial except for hearings. Times I've had to go accompany my attorney, Roger Phillips, in court. I'm unable to speak. I am a victim. I'm 2 years into this. I'm still waiting for probate to complete their job. I'm waiting on some jewelry, mother-daughter ring that I had purchased for my mom as a Christmas gift. Christmas of 2020. I'm still waiting for that ring, but until the criminal case is closed, along with probate matters, I'm unable to obtain that piece of jewelry, which is very difficult for me. Waiting on assets to be mine now or for down the road, and I will say it's been a challenge since Mother's been gone, living on my own completely. It's not been easy, and I have family that have turned their back on me that will visit him in prison, like county corrections, that is. And they have nothing to do with me, and they live in Manchester and down in Exeter. So that makes life extra difficult around the holidays. From time to time, I see Laura and Ronnie and Gizmo, the little dog that lived with us. He looks like Toto from Wizard of Oz. He's cute as a button. But I will say that on a harder note, my father was abusive over the years behind closed doors. A lot of times domestic violence goes unnoticed. Oftentimes you hear about police brutality over the news, and it's like not every police officer is a bad cop. And women or even men that face different forms of physical and mental abuse, it oftentimes is unheard and unnoticed, or it's overlooked. We had a social worker, Terry, who would come to the house, and I asked her when she wanted to send me pamphlets on what to do in regards to take care of matters at home safely, to please mail the packet to my apartment. That wasn't the case. It was sent to 71 South Spring Street. Luckily, I got the mail before my father did, because who knows what would have happened at that point. He used to hide mail all the time. So it was scary, living on edge over time. I wish the authorities had done a lot more, though. Perhaps had they taken him and put him in a facility before May 28th, this could have been prevented. I looked into assisted living for my mother because she needed more help than what my cousins and I could properly give towards the end of her life. And I wanted something done for him because I knew there were issues going on. But at the same time, I know that my mother lives on within me. I can carry on different traditions, which I have. Baking cookies and brownies throughout the community between Concord and Manchester, bringing goodies to my job. I'm a beauty advisor down at Ulta Beauty. I'm trying to get more hours at my job to really support myself more. And I'm longing to go back to school for nail technician. But in the meantime, I have a 1-bedroom apartment on the Heights. I still have to check on the house, and if anything goes on with it, it's my responsibility and I have to notify my attorney. I deal with mail, and as mail arrives that have to do with my father, I have to see that it goes to my attorney's office and they take it from there. Recently, there was a mix-up with mail going to the vacant home. I dealt with a break-in back in June of 21. Mother had a collection of lampshades. She used to make lampshades. It's kind of like a dying art. You don't hear much about that anymore. And she made beautiful lampshades. And she'd raise money for rescue farms and animal shelters throughout New Hampshire. And even as gifts. And 2 men broke in, trashed both porches, the front and the back porch. I found a few of the lampshades smashed. And it's like, you know, luckily I wasn't by myself. I had 2 friends with me, but I was a mess. I was crying and all upset because it's like, you know, the place is vacant, nobody's there. The place don't look right naturally. It's got a stale smell now. It's dead silent. I have hidden scars. To this day, I still have nightmares, severe nightmares. I'm on some meds through my doctors. But I stay strong. I joined a church community and I attend church every weekend now. I work, support myself. I volunteer at New Hampshire Food Bank. I like coming to different committees here at the State House. I help out at animal shelters as I can. I enjoy baking and cooking, and I enjoy when I'm able to. I like to paint. I like to do scenery and animals and characteristic drawings and various things. And I enjoy singing. Some Saturday nights when I have energy after work, I like singing at BT Lounge. So I sing soprano.
Ms. Kuchar?
Yes, ma'am.
Thank you.
You're welcome, ma'am.
Thank you for your testimony.
You're welcome.
We really appreciate it.
You're welcome,
We
ma'am.
appreciate hearing from you, and I would like to extend our committee's deepest condolences on your loss.
Thank you. I appreciate it. And thank you for the time to allow me to be able to share my story. And once again, I would like to thank law enforcement for all the times they came to the house to check on us and see that the home was, for the most part, secure. They put their lives on the line every day. Police officers, fire, ambulance, EMTs, different times they've come to the house. I will say one last thing. My birthday of last year, I ended up buying pizza and I brought it over to the firefighters over at RFD number 4 and for some of the police officers.
I'm sure that they really appreciated that gesture from you. It matters to show our first responders that we care about them.
Yes,
So thank
ma'am.
you for doing
Thank
that,
you.
ma'am.
Thank you.
Okay. I'm going to go ahead and close the public hearing on House Bill 135. We have no other business today, so we're done.
Okay.
And I will see you all on Thursday.